So allow me to begin. We will let the people in as they come in if they're having any issues connecting. It is late afternoon, so I want to welcome everyone, and I want to thank you all for joining us today. It is my distinct pleasure to introduce the speaker for today's event entitled IP Strategies for Entrepreneurs, uh, Dr. Martin Bader. Dr. Martin Bader, if you could just, the guys allow me, just give a little introduction. Dr. Martin Bader is a full professor of technology management and entrepreneurship at the University of Applied Science in Ingolstadt, Bavaria, Germany, a lecturer at the University of St. Gallen, Switzerland, and as well has served as an adjunct professor here at McGill University since October 2024. So not to cover absolutely everything that Professor Bader has done, let me just say that Professor Bader is a Swiss and European patent attorney and a representative before the United Patent Court. He's the founder and managing director of BGW IP GmbH St. Gallen, specializing in intellectual property and innovation management advisory. Previously Vice President and Chief Intellectual Capital Officer of Infineon Technologies, Professor Bader is a recognized IP strategist and long-term IAM Strategy 300 appointee. He serves as a mediator for the WIPO Mediation Center for Alternative Dispute Resolution and sits on the editorial boards of key journals. Professor Bader's well-known publications includes the bestsellers Patent Management and Intellectual Property Management for Startups. It is, again, with great pleasure that I pass the floor on to you, Professor Bader, for this tremendous and wonderful speech that I know is ahead.
Thank you, Robert. Yeah, welcome also from my side. I just would like to kick off with a short note to you. Imagine you as an entrepreneur have been reworking hard on your new company and your new venture. And while you start, or even before someone else starts a similar version, cheaper, faster, and better. So what do you do? Is that a fictive nightmare or is it a real nightmare? And of course, as history tells us, it might be a real nightmare. One that actually happened to the company art.com. I'm sure you don't know it, but it was like an artist company that worked together with a German Hamburg-based Chaos Computer Club that you might know, that basically invented a technology that later, at least that's what they claim, became Google Earth, what Google Earth is, what you know from Google Earth today. And they even had a patent on their technology. But in the end, eventually, after a while, they realized, or the actually court then revoked the patent as they had been speaking about the technology on a conference before filing the patent. And the conference was even recorded, so it was easy to prove before the court. So here we could say, okay, maybe it was great they had a patent, but it was invalid in the end, took a lot of time, a lot of thorough, and in case they had performed differently, they could have maybe used it in the interaction with Google. On the other hand, if they had not even taken the efforts to go for a patent, they had saved maybe a lot of time, but the business would still have gone. So, of course, we want to avoid this type of cases, and that's how I would like to kick off with a little poll to understand where you participants are around, and maybe Juan can kick off the poll. Nobody could do this for me. Should appear now. Can you see the poll? Yeah, and maybe it's a fixed answer, so maybe you can try to do that. So some answers coming in. Okay, so as we can see here in the group, we have about half-half. Half are familiar, half are not so much familiar. That's pretty cool. So yeah, if we can just take this as an understanding. And I would like to show you an example, a little case from Spotify. I guess you know Spotify, the music streaming or audio streaming platform, which started as a real startup at that time. And actually, they had to invent technology to make it happen. Which one was that you had this seamless streaming. So when you sort of start the music, it starts immediately, and they had to invent some technology to give the user this sort of this perception that when they press the button, the music would just start playing. And that taking into account these, let's say the limited bandwidth of the internet, also taking into account the the legal jungle almost at that time, given the power of the music industry on the one end, and the idea to offer seamless peer streaming of audio content. And they managed to do all this. And you could say, okay, what's now the USP, the unique selling point, the core of their business model? The business model, we call it freemium model. So you could start without paying, and then if you want more conveniency, then you would have to buy the paid version of them. But in all of those cases, the business model is on, let's say, on a transcription that user pays for time or for user content. And of course, when we talk about the business model, you can ask, okay, what is the key elements that makes this technology and the business model happen and work together? And then they looked for, okay, what is the best technology to get protected by patents? So in this case, it turned out to be that this seamless streaming was something that users really could judge compared to other technologies that also came up. So when you press a button and you have to wait or not, that would be something that users would really recognize and appreciate as a perceived quality of the system. So a patent on that or protecting such kind of technology would be very useful. And some of you might even know the case from not only from using it, but also from a Netflix miniseries. I'm showing some series today too, called The Playlist. So unless you already know it, I can only recommend to maybe once, if you're interested in this kind of stuff, maybe to watch one of those specifically this Netflix miniseries called The Playlist, or to read the book Spotify Untold, which also deals about building up that business. Compared to that, second case example called Napster. I guess many of you, I hope you know Napster. It was a peer-to-peer file sharing platform introduced much earlier to Spotify, but who did not care so much about sort of the legal jungle, the legal restrictions. And people loved the system a lot, but nobody cared about, let's say in this case, mainly copyright aspects that were attached to the shared music files. And of course, the music industry didn't like to watch this, especially when the user numbers were increasing and sales of music items were going down for the music industry. And so it took about like less than 2 years that they sued Napster, and Napster had sort of to back down, which is not so nice if you're starting a startup that you're put down this fast. And ironically, the brand was already so famous that it survived the case, that it survived the bankruptcy proceedings, and could be sold sort of to a sort of a successor that would use it. So Napster still exists today, but it's not the same anymore. Yeah. So what's the learning on that? That you can use IP, which is not only patents, I will come back to that, but to use it for create value, make it part of your venture case, and also use it for not only building value, but also managing your risk. And to make an example, which is not limited to those here, it might help to find investment because investors look for exclusive scalable cases. It might help build brand loyalty, especially when you are in the business to consumer domain. And it might help, especially when you come from research, for example, to enable licensing and help building up partnerships and keeping a chunk in what's going on. Okay, so to make an example, what are different IP types? And this won't be a legal presentation here, just to show it once to you. So we're talking about patents. Patents is one way to, maybe I can sign it off here for you. Yeah. So patents is an instrument, a legal instrument to protect inventions, technical inventions, and for a limited period of time, typically worldwide maximum 20 years. So you might say, okay, 20 years is long. I'm in a fast-running business. But if you take examples like maybe your iPhone, one of the most sort of valuable patents Apple had at that time was the slide bar when you sort of open the mobile phone and when you want to deblock it, something which is every user uses and which was very ergonomic, so easily to use. And if you get like some kind of these user interface related technology protected, it's very strong because users will see it and will see if someone else has to go around to use a different version. Users will see that it's very different. With patents, it's important to know that you can only get patents on unpublished content. So if you have so don't do it like art.com and in the case with Google Earth. Before you speak about your confidential ideas, consider whether it makes sense for you to get a patent protection on it, and then first file the patent about it, and then talk about it. That's one thing we really have to know. Another one are the design rights or design patents. Here on the watch could be how the watch looks like. It's also a way to protect your design, but basically all the large luxury brands protect their designs with design rights. Then we have the trademarks, which is the name, the logo, but can also be a smell, even a sound, or even a slogan. And one type which is very often overseen are the so-called trade secrets. That's those valuable things that are valuable to you because it's kept secret. It doesn't exist immediately, but you have to take action in, for example, saying, okay, this is really important for us, let's keep it secret. And a good reference to that would be for example, the recipe formula that Coca-Cola uses and that after more than 100 years, of course, has become a myth. Yeah, let's even a myth. It has become a myth and it's part of their DNA and probably brand identity. And the others, of course, copyright could be, for example, the one that you're using as a description of this watch. Could be if there's software included, could be the software code that runs the clock, or some other stuff. And at least in Switzerland, it's always important to say, where do we come from? For example, if you have a Swiss cross on it, then this is typically also protected. Another example could be if you use the term champagne. Champagne is, you cannot just call your bubble drink champagne unless it's produced in France in the Champagne under the local rules that are relevant for producing champagne. So in this is just an overview to show this to you. Now, what you might say, well, I'm a startup or a small medium enterprise, small company. What are they typically struggling with? You might know it or not, but of course, it's lack of awareness. You might say, I'm always fast, I don't care. And that might work for you unless you're well known. Yeah, as soon as you become uh, important, as soon as your business lifts up, then this might change very fast. I will show you an example later on. Then you might have another challenge is to know the right stuff. And you don't have to be an attorney to do this, but you might have to know when it's time to get the right people on board and what to do in advance and when you need or want additional support. It might also be that you don't care about your defense, nor how you can exploit your IP, ignore financial and legal risks. Again, the financial risks are smaller when you're a small company, but might become big when you're getting sort of more viable. The legal risk might be there anyways and might end up in a shutdown of your company. So we don't want to fully reduce those legal and financial risks, but we want to understand them typically, and we want to mitigate them based on the size of our business. And finally, of course, as a startup typically struggling with resources, you might underestimate or be overwhelmed with what's going on. For example, if you get a warning letter, don't throw it in the bin, take it serious and get the right action in place to deal with it. The earlier, the better, I would say. Okay, and the example I want to show to you, and I'm sure you know the company, of course, here in Montreal, but when Research in Motion, the mother company of BlackBerry, started their BlackBerry Adjunct 50 series, as soon as they were getting successful, you see, like 2 years later, there was a company basically that is, we call them patent assertion companies, a company that buys IP, that buys patents, with the aim to sue companies that are in the shadow of possibly using it and then building up claims. Typical US style IP litigation business. And in the end, I mean, you see that there were some years going on, so REM was sort of defending themselves, but in the end, before the court, it was like 2 days before shutdown, they had to decide, do we settle now for an incredible amount of settlement size, or do we risk it of being shut down? And they decided to pay the lump sum. And ironically, one has to say, those were 4 patents in dispute. They were revoked afterwards, but this is due to patent law, as it's like 2 cases, and one was decided before the other. They had to pay the lump sum and didn't take care so much about that those patents could be revoked afterwards. Basically, they could have also agreed on, in case the patents get revoked, they want the lump sum back. However, they were still very successful, but you can also see the learning here from you is, okay, even when you're a startup and you're scaling, things can become very fast, very big. And if you have the right budget in your pocket, of course, you might say, okay, even this size of call, you just buy it off. But at the same time, you could say, well, with this amount of money, you could have reinvested into research, and maybe in the end, RIM would have been better off. Yeah. So basically, your risk management must also grow with your success. Okay, and now I have an example for you. Maybe we want to share that. And imagine this is fictive. It's based on a real case, but it's fictive for the purpose so that we can talk about it. Imagine there is a startup that wants to produce smart reusable cups, uses some near-field communication technology that is integrated somehow in those cups, and tied to or linked to an app that tracks the usage or rewards to support sustainable behavior so that people would reuse it and not just throw it away or use other cups. And they would now be seeking funding. And let's say the funders are like engineers and designers. And now imagine with what we talked about, you would like to advise those funders, founders, sorry. And what types of IP, for example, should EcoGo as a startup maybe consider to get protected? How would those be aligned with their business goals? Actually, what are their business goals? And what risk do they might face if they just ignore these aspects? And if you don't mind, I would give you like 2 to 3 minutes, and maybe you want to use those 3 questions to make up some notes, and maybe we can share them in the chat, and we can grab them up and discuss them. Maybe you'd like to try this so we can can see how familiar you're already with those questions. So feel invited to maybe share some intermediate aspects in the chat so we can see and talk about it. So for instance, what would be interesting at what makes this cup special? What as a user would attract you to it? What kind of technology is used? What is new? What's the appearance? What could you do to make it really differentiating to other reusable cups? Maybe you want to share some thoughts. I think some people are already typing. Yes, so I just see here a copyright for the app code. Yes, so someone's programming the app and then would say, okay, this is protected by copyright. Cool. And we have here the CAB and the NFC, the near field communication technology. Yes, we could consider this. Yes. Then the design pattern, probably not for the one I showed to you, but if you make it a bit more designable, then yeah, exactly. Yeah, then we have the user interface. I think this is very important. The interfaces, these are like the, um, the areas where everyone has to go through it. The logo, the brand name, yeah, for trademarks. Yeah, different comments here. Okay, and yeah, please keep writing. And in between, I would like to draw your attention. Okay, imagine now that you have limited resources. Imagine the attorney would tell you, wow, this costs you so much money to do all this. If you have to focus and say, well, you have limited resources in HR, I mean, you have limited size of team and you have a limited, so far limited financial resources. And of course, you're not talking to an investor, but also they look for priorities and pragmatic behavior. What could be a way to decide on, okay, which is now the right IP I need? Sort of, what would be my IP strategy now to do? Like file everything what I can, like the sum of all your comments you had now. Yeah, now we see some comments here. Alignment with the business goals, but what could be the business goals for a smart cup startup? Yeah, the risk is there. You could be copied. So what can you do maybe if you consider all your business activities you can do and maybe your all this IP stuff types that we're already seeing here, what could that be? Yeah, I can reach further. IP for protecting the technology, like the app itself, yes. Um, yes. But if we now think about a prioritization as a startup with limited resources or talking to the investors saying, okay, what is the most important part to focus on? So we say here maybe the tech. Then the question is, what is the tech here? Is it maybe just the item, the NFC in the cup? Is it the app that reads something? Maybe what could that be? Yeah. Combination, yes. Maybe we can get one more. I could argue maybe there are already a lot of cups with NFC technology. Do we know this? Maybe we don't know it yet. So we could say maybe do some little investigation, some market research, do maybe other cups with this kind of technology or a similar type of technology exist and how are they used for what purpose? Yeah, they could do the improvement too. Question what type of improvement and how let's say how much value would you have in your hand afterwards, knowing that maybe you imagine you protect a certain sequence, certain algorithm in your app, but there would be 5 different ways how you could reprogram the app so it would have the same purpose or the same functioning, just with different coding. Then a patent or a copyright on this specific part would be, of course, diluted by those other workarounds, right? And actually, that what happened to the real case here. I can show this to you. So what they did not do actually, they did not file the patent on the cup or on the mug as such. I even displayed the number to you because it's more than this. So you can see, look, here is in the cup, they have NFC technology in the cup as such in the bottom, but also in the lid. So both items are tagged. And then if you look on their business model, the scalable business model is actually they didn't consider this to be the cup as such, but the whole handling system. So the core of the patent is not the mug or the cup, it's the whole handling system that comprises, of course, the mug or the cup, but also a collecting container in this case where you can place here in 26 the cups and in 27 the mugs, so the lids. And the whole system, how it's recognized that the cup is in there and the lid is in there and that can be washed later on, purified in a professional washing machine, dishwashing machine. Um, so based on the ideas just coming from the technology and from the sort of the inventive side, from the creative side, you could say, well, we could all do this, like the cup technology, the sensor, the app integration, maybe the trademark on the logo, maybe on the name and on the logo, actually. You could say, well, maybe the certain algorithms that they are using, including the manufacturing processes of the cups, you could keep this secret and say, well, this is very specific, nobody should know about it, and make a trade secret out of it. Copyright work, and you see, you already found a lot of those that I've already prepared, the user interface, marketing visuals, and so on. But from a business view, you might say, okay, whether the app is programmed this or that way might not make such a big difference. Second, is this EcoGo company really producing the cups, or are they maybe asking a provider just to build the cups for them, sort of giving this away? and seeing the main value in the handling and applying it to, in this case, for example, to work environments, in office environments where you would place the system and employees and office workers would just sort of use it, and seeing the most biggest value and the scalability of this business model in that handling system and sort of what customers perceive then in the end. Even saying in the end, you can take whatever cup you want to if it fits maybe certain requirements, like the technology part and also maybe the physical size of it. And actually, in this case, in the real case, they also did not limit this to cups, but also to eating bowls, which you might use for your lunch at work. And so you could say in the end, the most valuable technology protect, in this case with a patent, would be the whole handling system. And this is where they filed the patent on, and which is actually this US patent here. It's a granted US patent, is also protecting, or is the focused claim is on the whole handling system. Yeah. So the idea is not to only start from the technology side, say what can we do? This is like brainstorming, so that we could all do this. But for prioritization reasons, and also say what's the main reason or the main area which you should focus on, you can basically only solve it if you come from the business side, not from the technology, but from the business side, and would say, okay, from the business side, these are the areas where we have the highest value creation. This, if you're using a business model canvas, that's the part where you say, this is our own activities. This is the core of what we are doing. So there, the patent or whatever protection element type you're using here might be the most valuable. And this is where you should start with and where you should focus on. So both. And of course, you might say, well, in the beginning, as a startup, I might not even know my business because I'm pivoting every time. That would mean, okay, we have to pivot this too. We might have to pivot the technology. We might have to pivot the business goals. And so the prioritization might change. And this is likely, very obviously, the challenge in doing this. And of course, one way to start with is say, okay, I have this technology, maybe I try to get a patent on it. Fair enough, the investors might agree to that. However, if this piece of technology comes only an alternative to many others, then of course the patent also gets devalued in the same sense. And if you can direct it on that elements that are core to your value creation and the perceived value of the customers, then of course it's like having a better placed IP protection. Same for the manufacturing. To take the trade secret, if you're producing your own, then the manufacturing process might be something very important. If you're giving this to a provider that being placed somewhere in the world, and you just say, produce me that mug, you probably don't even own the manufacturing process. They're doing this for you. So you probably won't have any value in protecting those unless it becomes very, very important for you and for your business you are up to. Okay, any comments to that in between? Or questions? Does that sound reasonable to you? Okay. Then I have a second case, but it's basically for your own. So maybe now think of a real or hypothetical business, maybe one you're up to on your own, or one that you're interested in, and maybe try to do one more this sort of same IP approach. Maybe take some notes. What is the business idea? What are the key innovations or differentiators there? Like in the cup, is it the cup or the lid, or is it the handling system? What IP types you could consider to apply. And then sort of the combination, what business goals could be best supported by IP, and what risks or gaps would you see? And I would love that maybe one or two examples would be shared, but please only those where you would say it's not a confidential idea. So if you have a confidential idea you're working on, you can make your notes on your own, but please don't share them, to avoid a pitfall like we had with art.com example, the Google Earth example in the beginning. So please don't share confidential idea here in this session, as it's recorded and publicly available. But maybe we can share some questions on that, or share some, maybe some hypothetical cases uh, which you might like to discuss. Yeah, maybe you like to, I give you like 2 to 3 minutes, and we can still maybe have a short discussion on a fictitious case. Okay, I see from Yannick. We have come up with a process that is new and innovative. What kind of IP is best, trademark or patent? Yeah, with the process, depends on what kind of process it is. Imagine this was a production process. You could say, well, it's a very high competence that you have developed this production process. And from an outside perspective, would be very difficult, or from the end product, very difficult to even say how was it produced. And as patents are published, you might decide, okay, maybe a patent is not a good way to tackle this, but rather to keep it very confidential. Keeping something confidential today is not so easy actually in practice. So it might involve that you agree within your core group who is the core who knows about the production process, and sort of swearing in all those colleagues of knowing this is important for our value creation and we need to keep it secret. Sort of the mindset, the awareness, okay, what I'm doing here, it's limited to our group and we should keep it secret. Second, you could add a legal layer. If you have, like, for example, employment contracts, you could put this into your employment contract saying, look, you're part of a group that has access to or is in developing this process. So we ask you to keep it secret. And in case you're leaving the company, for example, then we ask you to keep this confidential even after your assignment or after retirement, for example. Third, it could mean that's already what Da Vinci started in the medieval time. You could even say maybe it's good that not everybody knows everything. So you might modularize this process and only some people know some parts. Nobody maybe understands, or only limited to a very, very small group knows how things are belonging together. So that's one physical way sort of to deal with keeping secrecies, that maybe not everybody knows everything. Um, so that could be a way how you deal with the process. If the process is very well seen maybe it's a chemical process, production process, and you could see it in the end on the product, then you might say, okay, if it's obvious seen in the product, then a patent might be a very good instrument to deal with it, to keep it in your hand. Also, there is important before you do it and publish it that you then would file the patent beforehand. Yeah. And you mentioned the trademark. Maybe if you can give a name to the process, like the better than ever process, you could say, well, this is our new trademark. We're using it as a trademark. So when people hear the name, they associate it with our process. And then you could argue maybe this is a good way to build up a brand based on this process. And that could be a name, it could be a logo, it could be a combination of it, could be maybe a sound. There's some sound marks. One you might know is the one from Intel Inside. Um, uh, and or actually the one from Forworks, now the kitchen machine. When you switch it on, then you also have a sound that is protected. Yeah, so different ways to do it. And typically, I would always suggest, coming from the business side, not only to look on the legal instruments, but also on the very business style tools to keep a business unique. Like, we are the best, we are the fastest, we have good teams on board, we have good suppliers, we have maybe access to resources that others don't have, and to be aware of this and then take the necessary action to enforce those. And very good examples, typically where it works, is a combination of both, sort of business instruments and IP instruments. Yeah. Do you have? Would you like still to share some more findings? I think we don't have more here. Yeah. Then to basically conclude. Maybe a repetition from an investor's perspective. You can ask investors. We actually did also here in Canada. There were like three key drivers for value development. One is the market. So if there's no market, nobody likes to invest in it. But a market here would also maybe have an IP command. What IP risk do you have? So imagine the EcoGo would offer their services, start their business, and then would have the same problem like RIM / BlackBerry infringing on IP rights of others, or like Napster's. Not good to start a business, right? Then the team, what investors typically look like, is there a certain IP savviness on the team available? So do they know when they have to do what action and to get what competences on board? For example, calling at the right time, the right supplier, the right service provider, the right law firm, and also to know, okay, where is it worth it to spend more resources on? Is it now the source code of the app, or is it maybe the technology that is necessary to run the whole handling system, to make a link to the CAP system? And finally, of course, the technology as such, where you can say, look, is there something that is relevant for the exclusive value creation? Is that part of technology? And if yes, were there some extra investments done to keep that possibly exclusive so you can handle it better? And the main mistakes we typically find, and this is nobody has to be ashamed of this, but it's the more you're aware of it, the better, of course, you can avoid them. Unaligned business and IP strategy. I think this is even in big companies still a challenge, because there the technology department they patent everything. The trademark, the brand department or marketing department, they do what they do, and the business people just try it and sell it. But there's no combination of those, which would help focus on resources and a strengthening of the value creation. And then depending on what's the situation, ownership rights, usage rights. For example, if you're spinning out from a university, if you're a spin-off from a company, if you get hold of a technology and don't know where it comes from, very unnice situations can be sort of created out of that. Employee invention rights might also be an issue if you don't know where the invention came from. And of course, especially on universities, if you have ongoing licensing obligations, most investors don't really like this. They want not royalty payments as a risk. They want equity as the right way to deal with risk. Yeah. So, and I'm concluding now, looking on the time, maybe with one final poll after this session. Now, I know it's a very short one. It's late afternoon on Friday. But how can you share with us how likely are you now to take action on developing of refining your IP strategy? Maybe you'd like to share this in the final poll. Juan, maybe you can kick off the second poll, please. Mhm. Yeah, maybe the other participants might also like to share. Only an educated guess. We don't track you, don't worry. Uh, okay, enough. So we get some answers. Okay, a bit more likely, not sure. Okay, no problem. Um, okay, yeah. And in case you want to continue on that, McGill also offers you two courses. One is the with EPIC together the IP summer courses, which start in July this year, which is already a long known course series in the summer, offered basically every year. And the second, which is new to the sort of to the portfolio, it's a course on IP strategy for business. So looking more on the managerial aspects, or from a managerial and business owner's perspective, or managerial, yeah, manager in a corporate environment or at the university that deals with technology transfer. That will start in October. Um, over to six times zero, it's will be virtual content, and where we will discuss more in deeply this type of questions and will offer yeah, best practices, successful practices, and insights to that. Yeah, and finally, to conclude for the session today, before we have to some time for some Q&A, the note for next week's info session from McGill's SCS.
So, Professor Bader, thank you. I'll take 2 seconds while everyone in the chat just add your comment or questions. This is tremendous session, and personally, thank you for choosing RIM and not Nortel. I don't know why everyone is Canada, they pick Nortel. But I wanted to mention that, and I put it in the chat here, we're going to have 2 information sessions on May 15th, one from 12 to 1 p.m. and another one in the evening, if you can't make it in the afternoon, from 6 to 7 p.m. We'll be able to answer some questions about how to apply to a program, what the next steps, what documents, any sort of funding and fees, any of the administrative questions you have. If you're not sure what you want to do next, it'd be a good opportunity to connect with some of the staff there. So I just want to let you know it's in the chat now, and I'll just kind of wait to see what kind of questions and comments pop up. But I think this was a tremendous session, to be quite honest with you. It's a lot more complicated than people realize. It's very nuanced, but still uh, somewhat clear. Like you know where the line is. It's just you got to know where you're looking. So if anyone has any questions, please feel free. I will monitor the chats. Some frantic typing. A lot of thank yous. I echo that. Let's thumbs up that. That's
Of course, we don't have to squeeze it. Maybe you have
no.
some confidential questions, then feel free to contact us bilaterally or to consider a later callback, whatever is feasible to you.
Ah,
And I think, Robert, we're also sharing the slide deck or the recorded session, so it will be easy to take some
Yeah,
more time. Yeah.
I apologize for that. Yes, I forgot to mention again towards the end, you will receive a link to this presentation to be able to watch it again. We have
Yeah,
a
thank you for
thank
the
you. Yeah, yeah.
sorry.
So, thank you
Oh,
for the
vielen Dank.
insights.
Okay. Yeah, vielen Dank. Yes, yeah, feel free to reach out. Can be very complex, but it's also sometimes so easy to do the basic steps. Feel free to connect via LinkedIn. Feel free to join SCS info session next week. Consider the courses we offer in summer and autumn, also in the field of IP. Yeah.
So yeah, so before we go, just again, I know October seems far away, but if you're interested, scan that QR code when you get it and sign up, because it does seem like it's a long time, but we're halfway through the year, so it comes up quickly, and you don't want to miss it. You want to book it. So when you get the presentation, I didn't put it in the chat, but you'll see the QR code, so scan that, because yeah, it fills fast, and share with your friends too if they weren't able to join. Okay. Well, I feel this is it. I think this is Friday. I think we call it a wrap. Professor Bader, thank you so much. I think on behalf of everyone, thank you. That was for less than an hour. I think I'm a lot smarter than I was 45 minutes ago. So thank you for your time, and thank you for this presentation, and thank you for everyone who attended. Tremendous, tremendous. Join us next week. You'll get the presentation. Scan for that October event if you want the summer too. So I wish you all a great weekend. It's going to be sunnier next week, but enjoy the weekend for now and get ready for next week. Thank you all again.
You too.